United States v. Awadallah, Second Circuit, 2003. Jacobs, Circuit Judge. This appeal, which arises from the government's investigation of the September 11, 2001 terrorist attacks, presents questions about the scope of the federal material witness statute and the government's powers of arrest and detention thereunder. The district court ruled that the statute cannot be applied constitutionally to a grand jury witness such as the defendant appellee, Osama Awadallah, and dismissed the perjury indictment against him as fruit of an illegal detention. We conclude that these rulings must be reversed and the indictment reinstated. Background. In the days immediately following September 11, 2001, the United States Attorney for the Southern District of New York initiated a grand jury investigation into the terrorist attacks. Investigators quickly identified Nawaf al-Hazim and Khalid al-Mindar as two of the hijackers on American Airlines Flight 77, which crashed into the Pentagon. The Justice Department released the identities of all 19 hijackers on Friday, September 14, 2001, and the news media around the country publicized their names and photographs the following day. A search of the car al-Hazim abandoned at Dulles Airport in Virginia produced a piece of paper with the notation Osama 589-5316. Federal agents tracked this number to a San Diego address at which the defendant, Osama Awadallah, had lived approximately 18 months earlier. Al-Hazmi and al-Mindar had also lived in the San Diego vicinity around that time. On the morning of September 20, 2001, federal agents went to Awadallah's current residence in San Diego. When the agents arrived at the apartment, Awadallah was attending a course in English as a second language at the nearby Grossmont College, where he was enrolled. The agents interviewed Awadallah's roommate in their apartment for several hours. When Awadallah came home around 2 p.m. that afternoon, several agents approached him as he entered the parking lot and got out of his car, a gray Honda. They questioned him in the parking lot for a few minutes and then told him that he had to accompany them to the FBI office for questioning. Awadallah insisted on returning to his apartment first to observe the afternoon Muslim prayer, which he did as the agents watched. When Awadallah went into the bathroom, the agents insisted that the bathroom door be left open. Before leaving for the FBI office, an agent asked Awadallah to sign a consent form allowing them to search his apartment and car. Otherwise, the agents told him, they would get a warrant and tear up his home. Believing he had no choice, Awadallah signed the form without reading it. The agents then put him in their car and drove him to the FBI office. Awadallah told them that he had to return in time for a 6 p.m. computer class. They told him that would be no problem. At the FBI offices, agents offered Awadallah a drink, but he declined because he was fasting. They asked him to sign another consent form for the search of his second car, an inoperative white Honda in the parking lot of his apartment building. This time, Awadallah read the form and learned that he had a right to refuse consent, and thought he signed the consent form for his second car. And though he signed the consent form for his second car, he explicitly revoked his consent for a search of the first car. An agent tried to reach the agents at the apartment building by cell phone, but did not reach them until 15 minutes later, after the search of the first car had been completed. The agents at the scene then searched the apartment and the second car. The search of Awadallah's home produced several computer-generated photographs of Osama bin Laden. The searches of his cars produced 2 videotapes on Bosnia and 1 on Islam, and a retractable razor, which could be described as a box cutter or a carpet knife. Awadallah was alone in a locked interview room for a while until agents arrived to question him. They did not advise him of his rights or tell him that he could leave. They asked him about the September 11th hijackers and about his life and acquaintances. He told the agents he knew al-Hazmi and he frequently had seen another man with him whose name he did not know. The district court found that Awadallah was cooperative throughout this questioning. When 6 p.m. approached, the agents told Awadallah that they had called his school and that it was all right for him to miss class. They told him he would have to stay with them until they were finished. The entire interview lasted approximately 6 hours, ending at nearly 11 p.m. Before allowing Awadallah to leave, the agents scheduled a polygraph examination for the next morning. At 6:30 a.m. the following day, September 21, 2001, Awadallah called the FBI and refused to come in for the polygraph test until he had a lawyer. The agent told him they would get an arrest warrant. Believing he had no choice, Awadallah went with 2 agents who picked him up at his apartment at 7 a.m. At the FBI office, agents advised Awadallah of his rights, and he signed an Advice of Rights acknowledgement form. The polygraph exam lasted 1.5 to 2 hours. Afterward, the agents told Awadallah that the polygraph registered lies in response to 2 questions: whether he had advanced knowledge of the September 11th attacks and whether he had participated in them in any way. It is unclear whether these were, in fact, the results. The conversation became heated as agents accused Awadallah of being a terrorist. They refused Awadallah's requests to call a lawyer and his brother and did not release him in time for Friday prayer. Throughout the questioning that day, the FBI agents in San Diego had been in contact with Assistant U.S. State's Attorney in New York. At approximately 2 p.m. Eastern Time, the state's attorney instructed the agents to arrest Awadallah as a material witness. The agents handcuffed Awadallah and took him to San Diego Correctional Center for booking. During the period of his detention, Awadallah spent time in 4 prisons as he was transferred to New York Correctional Center by way of Oklahoma City. He alleges that he received harsh and improper treatment during this period. Awadallah spent most of his time in solitary confinement, at times lacked access to his family, his lawyer, or a phone, and was repeatedly strip-searched. The government did not dispute that. By October 4, 2001, Awadallah had bruises on his upper arms, and an agent's report indicated several other injuries on his shoulders, ankles, hands, and face. Awadallah sometimes refrained from eating because the meals provided did not comply with his religious dietary restrictions. On October 10, 2001, 20 days after his arrest as a material witness, Awadallah testified before the grand jury in the Southern District of New York. The prosecutor questioned him for most of the day. In the course of his testimony, Awadallah denied knowledge of anyone named Khalid al-Mindar or Khalid. The government then showed him an examination booklet he had written in September, which the government obtained from his English teacher in San Diego. The booklet contained the following handwritten sentence: "One of the quietest people I have met is Nawaf, another one his name Khalid. They have stayed in San Diego for 6 months." Awadallah acknowledged that it was his examination booklet and that most of the writing in it was his own, but he denied that the name Khalid and a few other words on the page were written in his handwriting. On October 15, 2001, when Awadallah again appeared before a grand jury, he stated that his recollection of Khalid's name had been refreshed by his October 10 testimony and that the disputed writing in the exam booklet was, in fact, his own. However, he did not admit to making false statements in his first grand jury appearance. The United States Attorney for the Southern District of New York filed charges against Awadallah on 2 counts of making false statements to the grand jury in violation of 18 U.S.C. Section 1623, falsely denying that he knew Khalid al-Mindar and falsely denying that the handwriting in the exam booklet was his own. On November 27, 2001, the district court granted Awadallah's bail application. He satisfied the bail conditions and was released approximately 2 weeks later. In December 2001, Awadallah moved to dismiss the indictment. The court ruled that the federal material witness statute, 18 U.S.C. Section 3144, did not apply to grand jury witnesses. Judge Scheindlin ruled that Awadallah's perjured grand jury testimony had to be suppressed as fruit of this illegal arrest and detention. The government filed a timely notice of appeal. Discussion. Applicability of 18 U.S.C. Section 3144. The first issue presented is whether the federal material witness statute, 18 U.S.C. 3144, allows the arrest and detention of grand jury witnesses. As discussed in oral argument, we might evade this issue by holding that Awadallah's allegedly false testimony should not have been suppressed as fruit of the poisonous tree, even if his detention under 3144 was improper, and that the indictment therefore should not have been dismissed. We reach the issue, however, because the present split within our circuit on the scope of 3144 affects the liberty interests of persons identified as material witnesses, the security and law enforcement interests of the government, and the ability of courts to make prompt and fair rulings on present and future detentions. Section 3144, titled Release or Detention of a Material Witness, provides in its entirety: if it appears from affidavit filed by a party that the testimony of a person is material in a criminal proceeding, and if it is shown that it may become impracticable to secure the presence of that person by subpoena, a judicial officer may order the arrest of that person, and treat the person in accordance with the provisions of Section 3142 of this title. No material witness may be detained because of inability to comply with any condition of release if the testimony of such witness can adequately be secured by deposition, and if further detention is not necessary to prevent a failure of justice, release of a material witness may be delayed for a reasonable period of time until the deposition of the witness can be taken pursuant to the federal rules of criminal procedure. The statute is cast in terms of a material witness in a criminal proceeding. The decisive question here is whether that term encompasses proceedings before a grand jury. Given the broad language of the statute, its legislative history, the substantial body of case law indicating that there is no constitutional impediment to detention of grand jury witnesses, and the unquestioned application of the statute to grand jury witnesses over a period of decades before Awadallah, to perceive a congressional intention that grand jury witnesses be excluded from the reach of Section 3144 is to perceive something that is not there. We conclude that the district court's ruling in this case must be reversed. Section 3144 applies to witnesses whose testimony is material in a criminal proceeding. Criminal proceeding is a broad and capacious term, and there is good reason to conclude that it includes a grand jury proceeding. The term criminal proceeding has been construed in other statutes to encompass grand jury proceedings. Notwithstanding this support for the general view that criminal proceedings encompass grand jury proceedings, however, we cannot say that the statutory wording alone compels that conclusion. Black's Law Dictionary defines a criminal proceeding as a proceeding instituted to determine a person's guilt or innocence, or to set a convicted person's punishment, a criminal hearing or trial. Defined this way, a grand jury proceeding is not a proceeding instituted to determine a person's guilt or innocence or to set a convicted person's punishment, but rather a proceeding to decide whether to issue indictments. For these reasons, we must look beyond the text of 3144 to discern the meaning of criminal proceeding. In surveying legislative history, we have repeatedly stated that the authoritative source for finding the legislature's intent lies in the committee reports on the bill. Here, the Senate committee report states, in so many words, the intent to include grand jury proceedings with the ambit of the statute, an intent that is consistent with the statute's language, even if not compelled by it. The Fourth Amendment prohibits unreasonable searches and seizures. Determining the reasonableness of a seizure involves a balancing of competing interests. The essential purpose of the proscriptions in the Fourth Amendment is to impose a standard of reasonableness upon the exercise of discretion by government officials, including law enforcement agents, in order to safeguard the privacy and security of individuals against arbitrary invasions. Thus, the permissibility of a particular law enforcement practice is judged by balancing its intrusion on the individual's Fourth Amendment interests against its promotion of legitimate governmental interests. In its balancing analysis, the district court found that the only legitimate reason to detain a grand jury witness is to aid in an ex parte investigation to determine whether a crime has been committed and whether criminal proceedings should be instituted against any person. This is no small interest. The grand jury is an integral part of our constitutional heritage, which was brought to this country with the common law. Indispensable to the exercise of its power is the authority to compel the attendance and testimony of witnesses. The district court noted, and we agree, that it would be improper for the government to use 3144 for other ends, such as the detention of persons suspected of criminal activity for which probable cause has not yet been established. However, the district court made no finding, and we see no evidence to suggest, that the government arrested Awadallah for any purpose other than to secure information material to a grand jury investigation. Moreover, that grand jury was investigating the September 11th terrorist attacks. The particular governmental interests at stake, therefore, were the indictment and successful prosecution of terrorists whose attack, if committed by a sovereign, would have been tantamount to war, and the discovery of conspirators' means, contacts, and operations in order to forestall future attacks. On the other side of the balance, the district court found in essence that 3144 was not calibrated to minimize the intrusion on the liberty of a grand jury witness. We agree with the district court, of course, that arrest and detention are significant infringements on liberty, but we conclude that 3144 sufficiently limits that infringement and reasonably balances it against the government's countervailing interests. Given the procedural safeguards of 3144 that provide that no material witness may be detained because of inability to comply with any condition of release if the testimony of such witness can adequately be secured by deposition, and that detention must be necessary to prevent a failure of justice, we disagree with the district court's balancing of interests. Postscript. Osama Awadallah was ultimately tried on charges of lying to a grand jury investigating the terrorist attacks. His first trial ended in a hung jury, 11-1 for conviction. However, after a retrial, he was acquitted of all charges.